Good afternoon and welcome to today's webinar on the mystery of legal terms in contracts. Ian Moody, our presenter, is going to give us a simple guide. Just before we start our webinar, I'm just going to run you through a few housekeeping rules to help the afternoon go smoothly. The slides that you see and the recording of the entire webinar will be available to you on our SlideShare page as well as our YouTube channel, and we will email you the links to these after the webinar is over. When we finish, a survey will pop up, and I just ask that you'll please give some time to do the survey and give us feedback to help us improve on what we do. As you're listening to Ian talking, you might have questions, and you'll notice at the bottom right of your control panel there's a question box. This is the place to communicate with us. If there's a problem or you can't hear us very well or you just want to ask a question, that's where to type it in. And Ian already has scheduled the webinar to take your questions and answer them right at the end. So without any more delay, I'll hand you over to him. Thank you very much for being here.
Good afternoon, everyone. I hope we're all well. I won't bother to read that to you. You can see who I am for your own sake, and obviously you can look at that later. So contract terms. Let me just get the ball moving by saying what we're really looking at now is relating the set of contract terms into best practice within procurement purchasing activity. The reason for the slide you can see there is it says quite clearly within the purchasing cycle that we should always set contract terms before we approach suppliers. It is a primary duty of purchasing and procurement people to understand and make sure that the contract terms that are being used by the organization are applicable to the type of buy they're about to do. Therefore, whilst procurement people do not need to be legal experts, they do need to understand the implication of these terms and how they may input on risk within the organization. So it's a very important issue. Okay, in simple terms, contract terms are the objective. They're one of the two key objectives related to the specification. So you must have them before you go out. Right. So there's a purchasing cycle. I'm sure anybody who knows anything about procurement activity will know what that is and how it works, but it's just there to remind us and get us moving in the right direction. Let's start with a very simple thing. What is a contract? Many people seem to believe the contract is related to value or size or duration. It's not. You form a contract every time you buy or sell something. So if you go into the shop and you buy yourself a bottle of water, you are forming a legal contract. So it doesn't have to be buying millions of dollars of equipment. It doesn't have to be major capital purchases. It doesn't have to be related to 3, 4, 5 years or whatever the duration of that contract may be. It is simply exactly what it says it is. It's an agreement between two or more parties that have agreed to exchange something. It's basically referred to as exchange something of value. Value is an interesting concept, but it doesn't have to be money, but it usually is. There will be conditions and contingencies about that contract. There are rights of each party, and they need to be underlined in the contract. So initially, a really important point is when contracts are produced, they must be fair. They must be fair, they must be equitable to both sides. So you cannot have contracts that are written that are only in favor of the buyer or only in favor of the seller. The contract is to protect both parties by laying down what has been agreed. It also will cover in the contract liability. What happens if there is a problem? It will also lay down how disputes will be resolved. And finally, of course, it can be orally or in writing. It does not have to be in writing. As I said when we just started this, if you go to the shop to buy yourself a bottle of water, you are making a legally binding contract. You don't write that down. It's still a contract in law though. So it's very important to understand. Now that is why, from commercial points of view, working commercial companies, we tend to only do things in writing in order to ensure there is no confusion. Everybody can agree. But please, as I said, is to protect both parties. All right, a contract. The problem arises when we start talking about under jurisdiction. Which law applies? Local law? But whose? Whose local law? Is it the buyer's local law? Is it the seller's local law? Okay, so in simple terms, here we are in the UAE. You want to do a piece of business with a company in the UK. Do you set the contract under UAE law or do you set it under UK law? If you set it under UAE law and you go to court, the case will be heard here in the UAE. The problem now is if that company in the UK say, we don't care, we're not going to do anything, we just don't mind what you come up with, then the UAE courts cannot enforce any judgment in the UK. So if you were doing a contract with a UK company, it might be worth considering doing it under UK law, because then the case will be heard in the UK courts, and the UK courts can enforce their decision on UK companies. So something to think about very clearly. Now, obviously, that's not just UK, UAE, it's all over the world. So what a lot of people have done is they said, well, that's okay. We will use UNICITL, the United Nations Convention on Contracts for International Sales of Goods, written under the Vienna Convention. Great, but not. Because not all countries have ratified the UNICITL rulings. Particularly notably is the UK. It is not ratified in the UK. Because it's not ratified in the UK, it cannot be enforced in the UK. The main reason for that is that the UK courts will argue that UK contract law is stronger than any other contract law anywhere in the world. And there is some truth behind that, because UK contract law, the body of law that creates contracts around the world, is all based off UK contract law. Everybody bases their laws on it. So you'll be a bit careful. So if you use UNICITL, you've got another set of problems to worry about, because it may not still be enforceable. And even if you've decided to do it, where does the case get held? Because, my friends, there is no such thing as an international court for contract. It doesn't exist. The case will be held in the country in which the contract was signed. Now, can it be enforced if people say, we don't care? Potentially not. So you're back where you started. My advice is, when writing contracts, to seriously consider forming them under the law of the state from which you are buying. Now, this is not common practice with all companies. It's not common practice generally here within the Gulf states. But it is becoming common practice because companies are beginning to realize it's the only way they've got a good chance of enforcing any court ruling. However, we must remember that if you got yourself into the position where you have to go to court, if you have to start waving the contract in the air and start saying, this is what the contract says, this is what the contract says, you are now in trouble already, because you just lost your supplier. You've lost your supply. You've damaged your business. So be extremely careful by by simply relying on the contract to get you out of trouble, because you're in trouble. It's foolish. All right. So I do hope that that kind of clears up a few points, because it's quite important. Let's look at different ways in which I may go about doing this. In simple terms, we talk about spot purchases. Spot purchases require different sets of terms than other kinds of contracts, because they are one-offs. They don't reoccur. right? They're not long-term, they're single buys. They might be very low value purchases. They may be one-off services. They may be very high value. You might be a contract for a building or something. Remember, time is not the point. But you don't do it every day. You don't keep going into it. It's not a systems contract, spot purchase. Now, they require sets of terms, and those terms will be different because by nature, they require different outputs. Main features of a spot buy. It commits both buyer and supplier to all the terms relevant to the supply of the specified requirement. Okay. It only commits buyer and supplier to the purchase and supply of that requirement in that specific case. That is to say, it doesn't take you into long-term buying agreements. It's the one-off, whether that one-off period lasts for 1 hour, 1 minute, 1 year, I don't know. Doesn't matter. It's a one-off against those terms. So it needs its own terms. There are other ways in which we might consider setting up contracts. And again, they all need different terms. Standing offers, right? Standing offers, general open offers that could be accepted at any one point. Blanket ordering. Blanket, a lot of people misunderstand blanket ordering. The system of blanket ordering is used when you don't know exactly what the quantities are going to be. So what you do is you set up an order that allows you to buy up to a certain value, but it doesn't actually agree that you will buy all of it. Blanket ordering. That will need different kinds of terms. Call off. That's when you know how many you're going to take, but you don't want to take them all in one go. You spread the delivery against the schedule. So call off contract is different than a blanket one, used for different reasons, and they need different terms. Systems, very broad general arrangements under which you might use to get reoccurring procurement activities. Term contracts, contracts that might become renewable or not renewable. So what we got? We've got spot, one set of terms. Standing offers, another set of terms. Blanket ordering, another set of terms. Call-off contracts, another set of terms. System contracts, another set of terms. Term contracts, 5 sets, 6 already. Different sets of terms. Most people carrying only 1 or 2. But we haven't even talked about CapEx and OpEx type contracts. We haven't talked about long-term service contracts. Oh, it's getting complicated, very complicated. About framework agreements. A framework agreement it's used in order to lay down all of the terms except the final price and delivery. So everybody's connected into it. All the terms have been pre-agreed except you haven't got the final price and delivery. So framework agreements are set up, and then what happens is when you actually want them, you then use a spot contract. So you need another set of terms. You need terms to carry the framework agreements, and then you're going to carry into the spot order. Used for all sorts of different reasons. It is relevant that we understand this. Framework agreements are commonly used now by governments. They like it because it does all the tendering process. It has agreed tender procedures where the people are in the framework for 4 years, for example, and during that time, all you're doing is pulling off. You can now use electronic systems of reverse auctioning systems to get the lowest bid, lowest compliant bid system. So they're loved by governments and they're becoming very, very common. It works very, very well with tender law all around the world. Framework agreements, another set of different terms. All right, terms. Let's start from the top. There are things that legal minds will say are nominate or innominate terms. Don't worry about those. They simply mean named or unnamed. We have, under those banners, express terms. When you express something, you say exactly what you think. You express yourself. So an express term is the details of that contract specifically and mutually agreed upon before or during the time of the contract. You may not add a term of any kind to a contract after the contract has been agreed. The contract would be voided if you did that. It does not exist. You may not alter an existing contract. Contract amendment is a very dangerous thing to do legally. It is better to terminate the contract and then issue a new one. It's a very important fact, actually. But anyway, an express term. It's a term that you actually explain. Now, this might be price, it might be delivery, it might be payment, it could be many different things, but it's expressed in detail. There are also implied terms of contract. These are terms that do not need to be expressed, but they are always there. They're implied by the fact that you have a contract. They do not need to be explicitly agreed by both parties because they are always there. The reason is that they're implied through statute. Statute is a legal term that means it's set in stone. A statute stone, it's set by law. You may not write a term that undermines statute. So you may not write an express term that undermines an implied term. The implied term is always there. So for example, in UK law, we have an act of law that applies to contract called the Late Payments Act 2002. In the Late Payments Act, it says if you do not pay me within 30 days, I have the right to claim 8% plus the base rate interest, which is then recalculated by every day. So that's the APR, annual figure, 8% plus the base rate, which is then divided by 365 multiplied by the amount of days late. And I have the right to charge for that under UK law, Late Payments Act. You may therefore not write a term in the express term that attempts to remove that because it is always there. Under the Act, it says payment must be made in 30 days or less. So you may not write a term that says I will pay you in 45 days. Irrelevant to whether people agree it or do not agree it, it is against the law. And you cannot agree things that are against the law. Right? We cannot agree to go out and shoot someone and pay me money, for example, to go and do it, and then I don't do it and you want your money back. Forget it. It's not going to happen. There is also another area of implied terms, and it's called common law. Common law is what contract is basically about. Some of it is statute law, but some of it is common law. And it's based on the idea that there have been cases over the years gone through the courts, and the judges have made rulings. Once they do that, that becomes a ruling relevant to that particular situation. Therefore, a judge's ruling in a particular contract case is in common law, and it will be therefore deemed to be an implied term unless you can argue that it doesn't apply. It exists. Now, one of the problems with UK law is because UK law is so very old, and because the body of contract law is so vast, you could literally fill rooms and rooms and rooms with books. We have law that goes back a very long time. So when you study law for a UK contract, we have laws that are still being used in the courts today that go back at least 200 years. And they're used every single day. Any law student will go out and learn case Hyde versus Wrench, Ollie versus Marlborough Court Hotel, Connie versus Stevenson, all these different legal cases that prove different areas of contractual problems. We also have implied terms because of things called commercial custom. Guys, if a construction project is late, do not take the constructor to court, because he will claim commercial custom. He will claim it's not my fault, it's the weather. I do not control the weather. It's commercial custom. That's what he'll say, and on you will go. You need to be extremely careful. But the point is, remember, an express term is one that you actually express in detail. An implied term is one that is always there. So Buyer beware. If you do not know the law that you are using and you do not understand it, every time someone picks up a telephone and orders a pencil, you are putting yourself into a contractual position in law. You better know what you're doing. Most buy purchase contracts do not involve legal departments. And I will be honest with you, many companies' legal departments do not in detail understand contract. So we need to be extremely careful with that. But beware, you can be in a lot of trouble very quickly. One of the biggest problems is most people don't even know the difference between offer and acceptance. Most people think that a purchase order is automatically an offer. It may not be at all. Sorry, I should have said a quotation. Forgive me. A quotation is an offer. It may not be. The purchase order may be the offer. People do not understand the process. Now, that's not to do with contract term. That is to do with legal and the way in which contracts are formed. And that's not what this is about. But, you know, it's a really important issue. But people need to understand that it's quite important. Implied terms, more. Implied terms are implied by the nature and virtue of the contract. All right? But they have to be related not only to those areas I've mentioned, but the need for business efficacy. We have to understand the need of the business before we start going too far. So what do we got? We've got all these different types of terms depending on the way in which we're buying. We've got all of the different types of terms depending on whether or not we have international law or local law and which law it is, and etc., etc. Piles of different types of terms. Then we have them implied or expressed. You may have noticed I haven't yet said terms and conditions. I've only said terms. There's a very good reason for that. It is a misuse of words. It is common in business practice for people to say T's and C's, terms and conditions, but you don't need to. A condition is a kind of term. It's a type of term. A lot of people think that terms means money. It doesn't. Money is a kind of term. A condition is a kind of term. Let's see if we can get past that one. There are two key bodies of term that sit under implied and express terms. Some implied terms are conditions, some implied terms are warranties. Some express terms are conditions, some are warranties. Depends. It's easy with implied terms because statute law will explain it. It's not so easy with express terms on which are conditions and which are warranties. However, I would say that normally, and normally is a word I have to use when we use legal because I have no idea what a court would say, but normally time is not considered a condition, it's considered a warranty. A condition is a major term of contract. If something goes wrong, the contract is broken, breached by either party, by the buyer or the seller, the party that is injured, damaged, may seek damages by way of recompense, but they're only allowed to seek damages for their loss. They can't say, oh, well, you know, I feel hurt or I'm upset. You know, you can't seek damages that you haven't lost. You have to have a loss and you're going to have to prove it. Also with a condition, it allows that party to terminate the contract if they so wish. So a major term of contract is a condition. Some of them are implied, some of them are expressed. Implied is simple because the law says what they are. Expressed, more difficult. However, if it's a condition, it allows damages and it allows also termination. You don't have to do either. That's up to you, but it allows it. But if it's an express term, you have to express it in detail in the contract. And it has to be very clear that that term is fully covered as a condition and what this means and under what circumstances you will seek damages and on what circumstance you may or may not terminate contract. A warranty. People use the word warranty all the time. They're always talking about what is the warranty. They don't mean that. What they mean is what is the guarantee. And a warranty and a guarantee are not quite the same thing. A guarantee is a warranty term, but a warranty is quite simply explained as a minor term of a contract where you can seek damages, but you may not terminate the contract. You can only get damages against your loss. Guarantees are a kind of warranty, but people tend to use the word warranty incorrectly. And this is what happens, you know, in law is a language all of its own. It's a language you have to understand and start to know how it works. So we misuse words all the time. We say things we don't mean. But unfortunately, if you find yourself in a court, that's no excuse. And as far as the court is concerned, you cannot say, I didn't know, because they don't want to hear it. There is no excuse for ignorance in law. Lack of knowledge is not a defense in the court. They will not accept it, because if they did, they would then have to do things like saying, well, I didn't know murder was wrong, so I killed people. They're never going to give in on that one. You cannot plead, I didn't know. The comment from the court will be, well, you should have done. That's it. And purchasing people, procurement people, you are getting yourselves into contractual positions all day and every day. And what's even more basic than that, every single human being buys and sells things. And we're putting ourselves in contractual positions and we don't know we're doing it. Now, you know, 90, 95% of the time, it never matters. It's never a problem. But it could be. So, okay. General structure of a contract. How do they structure? It always starts by the name and nature of the agreement. It gives the name and the signatories of the party. That is, of course, assuming it is a written contract. Definition. It defines all of the names and the terms and how things will be done. It does that to avoid long sentences. So normally when you pick up a commercial contract, you'll find a lot of definitions to begin with, and that's what we would expect. If they're not in your contract, they should be. Then it will outlay all the general terms, the general agreement clauses. It will outline basically under what law the contract is written, how variations may be used, and please, a variation clause is not an amended clause. It's not the same thing. Variation clauses do not do that. Notice clauses, what you need to do related to contract, etc. And then all the general commercial provisions. Most of the commercial provisions are going to be simply related to the express terms, but some of them will be implied. Typically, passing of title or ownership. When does it become ours? We bought it, but when is it ours in law? In simple terms, until you've paid for it, you have no legal right over it. It is common business practice to buy things on credit. It is common business practice to use them or amend them in some way through a production process before you have paid for them. But you have no legal right to do it. It is, in fact, if you think about this, somebody gives you something to use, you don't pay. So until the time that you've paid, you are then actually taking their property. So if you use it before you pay for it, it is almost like stealing. When does it pass? Now, we get this often with international sales of goods. People tend to use letters of credit. These days, we use letters of credit a lot. Most suppliers will want the letter of credit to be irrevocable. That means it can't be pulled back. They also want it to go through their bank when the bill of lading is issued. So they get it before you get the goods. You have to negotiate your problem around that one. But remember, until you've paid for it, it isn't yours. Do not fall into the trap of thinking the Incoterms have anything to do with payment or ownership. They don't. They're only due to the right to ship, insure, and manage excise duties. They have nothing to do with payment. They have nothing to do with ownership. Time of performance. How long is a contract going to last? When must it be managed by? Key days. Inspection and testing methods. How are they going to be done? I've had contracts that require many types of inspection. But it better be correct, because if you're expecting your supplier to come and visit you 5 times a month to come and view something or inspect something in your premises, or come to meetings, for example, or test products, if he doesn't know that, he can't price for it. So you can't do it after, it's got to be done before. Delivery, packaging, well, delivery. Packaging is a very big cost. When you're shipping things internationally, you need different packaging depending on how you're going to ship. And because of that, you've got a cost to be added. So that needs to be written in the contract. What is required? Because if it's not, they will use their standard packaging, the goods will be damaged, and that becomes your problem. Assignment. How is the contract going to be assigned from one party to another? Where's the liability for damage? Where's the liability for loss in transport? Normally that's covered through Incoterms. And it will clearly state from which one of the 13 terms you've selected. How and when will rejection be used? How would you reject something? Under what terms do you reject it? Over what period do you have to reject? There's people who will get things shipped and they'll reject them 3 months afterwards because they put them in the warehouse. Unacceptable. It would be deemed unfair. But it does happen. Payment terms. Well, I've only started to talk about those. But all these things need to be done. What is the currency of the contract? What's best? The point is that if you're buying internationally, you will always get a better deal by using the currency that is local to your supplier. Always. Unless their currency is pegged against your currency pegging. So here people are pegged normally against the USD, and the US dollars for most international contracts. But if you want to go and buy from a company in Europe, it's no use to them. They don't need your dollars. They need euros, they need pounds, they need something else. But they certainly don't need dollars. It's no use. So they will charge you more. So you better think about these things. How do you get the best deal? But it has to be clearly expressed in the contract. So general contract terms, structure. Secondary commercial terms. What about confidentiality? Intellectual property? Do you have them? Do you have confidentiality agreements? Do you promise not to disclose any confidential information about your suppliers? Because you often will ask them the other way around, but you should do it too. All confidentiality clauses should always be signed by both parties. As I started here, I said contracts must be equitable and fair to both parties. It's a very important issue, confidentiality clauses. How long do they last for? Are they enforceable in law? Intellectual property. Intellectual property is certainly in consultancy projects, you might have intellectual property. In engineering, design projects, there might well be intellectual property. Indemnity. Do you have third-party indemnity in case something goes wrong? Who indemnifies who against loss? With global supply chains and complexity of global supply chains, indemnity is becoming more and more and more important. Indemnity is, for example, if you take a very simple example to explain indemnity, you buy a car from a a dealer. So you buy a Toyota. So you're off to the Toyota dealer and you buy the car. Something goes wrong with that car under its guarantee. You made the contract with the dealer, so your contractual obligation is with him. So you go back to that dealer and you say, I need this fixing. He can't fix it. But because there is a guarantee in place, which is an indemnity guarantee from Toyota, Toyota will now have that car fixed at their expense. But you can't go direct to Toyota because your contract is not with Toyota. Your contract is with the dealer, whoever that may be. Termination. How do you deal with it? Arbitration. What happens if you can't agree something and you feel you need an independent body to come and help you? Under the International Convention, under the Vienna Convention, there are a whole set of rules laid down for arbitration and how it should be done. But remember, can it be enforced? Other general standard clauses that you might find in contracts. Waiver clauses, force majeure, we all understand that, and the law and of course the jurisdiction of that law will all have to be stated. So let's just go backwards for a moment. The agreement, definitions, general terms, commercial provisions, secondary commercial terms, standard clauses that appear in contracts. Remember, conditions, warranties, they need to be in there. Okay. So when we create a contract, what is the form of this contract? Maybe you use your company standard terms, but I've already indicated most companies do not have sufficient standard terms. They're only carrying 2 or 3, maybe 4. They do not have what they need. Try to tailor their terms for each individual contract. You bespoke them. It needs a high level of expertise not to make mistakes. You're forever doing it. Or maybe you could get out of that problem and you could use what we call model terms. Model terms are industry standard terms. Most professional bodies have sets of model terms that you can buy from them. Internationally, for construction projects, we tend to use FIDIC. The FIDIC terms is laid down in the red, blue, yellow, silver book, are different sets of terms for different uses for international contracts. So they are used by different companies depending on what their need is for that contract, but they're all different, so you need to understand how to use model terms. Luckily, most contractors, most architectural practices, most design practices, most QSs and project management companies will accept them because they're used to using them. But now you're working under the FIDIC terms. Enforceability is another problem. But anyway, they're there. There are many others. If you look at the Institute of Procurement and Supply, for example, SIPs have got sets of terms that you can buy from them, be different uses. Service contracts, lots of different ones. Some of them are free, some you have to pay, not expensive. If you want, you can use things like JCT, Joint Contracts Tribunal, Institute of Electrical Engineers, and so on and so on. There are a pile of different sets of terms. We can't possibly, in this very short period, go into all of this. But if you're going to be involved in this process, you better start to understand it. There are still problems by using these. They don't cover everything. You still need training. People need to be trained to make sure they form the contract properly and correctly. And they don't do anything that could damage it. As I say, some of the organizations you might get model terms from, part of them there, lots of them, but you could use them. I guess you could argue that the Incoterms are a model set of terms, but they're very limited for what you use them for. They only cover insurance, freight responsibility, etc. They don't cover everything. Model forms. Some of the advantages and disadvantages, perhaps, of using model terms. Advantages: time, cost. Don't reinvent the wheel. Disadvantage is you still got to train people. You still might need legal advice. So, you know, there's an issue related to those. But some of the advantages and disadvantages for you. Interpretation of terms. What are you trying to achieve? What did you want? What are you trying to get? What are the legal, operational effects or implication of any clause for a supplier or a buyer? Right? How might a given clause in a contract make a supplier react? Might they say, you know what? I don't want to do business with you. I'm not interested in your business. Go away. Now, believe me, I have done that. Many times I have refused to sign contracts. And people have looked at me as if I'm crazy. I don't need your business in order to damage my business. I have to protect myself. Okay. All right. So we need to think about that. Make sure we fully understand. So everybody's interest must be expressed and understand. Indemnity, as I say, I mentioned indemnity a few moments ago, but it is a way that one party has a right or gives rights of protection to another one who we did not sell to. Okay. And that's what that means, indemnity clauses. Compensations are given in indemnities, right? You can say, for example, a supplier indemnifies the buyer against all costs or claims incurred by the buyer as a result from the supplier's breach of any obligation contained within this contract. It's a typical indemnity clause. Okay. Insurance. You need to build in insurances in. Different kinds of insurance. There's all kinds of insurance. Employer's liability, public liability, professional indemnity insurance. Architect builds a building, the building falls down. Professional indemnity insurance. Product liability insurance, etc. Loads of different kinds of insurances. You need to make sure there's insurance terms built into these contracts. What happens when it all goes wrong? When there's a breach? What are you going to do? How does that work? How are you going to deal with it? It must be explained in the contract terms. If it's under express law, if it's an express term, it must be explained. If it's implied, it might be covered. Maybe not, but you need to know what the law is. Contracts are often called frustrated, where it is impossible to carry out the contract. It's not somebody does something wrong, it just becomes impossible. So destruction of the subject matter of the contract, a non-occurrence of an event which the contract was based on. So, you know, for example, what would be a non-current event? You might have a contract to build a new building because you're going to move premises, but then for some reason or other you don't move premises, you're not going to do it, so the building is no longer, it's a frustrated contract. So all you need to do is now pay the level of fees that are outstanding. Incapacity to provide personal performance. Well, that might be because somebody said into the contract is ill, sick, has died. You can't make someone who's dead carry out a contract. It's not possible. Extensive interruption, which makes further contractual completion totally impractical. That could happen for all sorts of reasons. These are known as frustration. And the way that you pay against frustration is not the same as it is for other breaches. Now, as we come to the end, because we are coming very close to the end, and may I say, please, if we haven't got any time, and if you have got questions, please feel free to email them in, and we will answer them to the best of our ability as soon as possible. Let me come to the end. Liquidated damages versus penalties. In this region, people use the word penalty. It should not appear in your contract at all. It is a misuse of words. Penalties are a punishment. The American word prison In America, instead of using the word prison, they use the word penitentiary. They penalize people. You have a penal code. The only people allowed to punish people are judges and potentially God. You may not punish anyone. So we have to take extreme care. If you end up in a court and the court believe that the clause in the contract is designed as a penalty, you will simply be told to go away. It is not the same thing as a damage. One of the ways to get past that problem is to remove the word penalty and simply replace it with the word damages, and then detail whether they're liquidated or unliquidated and how and what will happen. But be careful when you design the damage clause. You do not design it in such a way that it could be assumed to be a penalty. This is a commercial agreement. It is not criminal law. You are not allowed to penalize. I know it exists here. In a slight side note, Islamic law strictly prohibits the use of penalties. It will allow liquidated damage provisions in order to get contractual damages back, but it will not allow penalties under Islamic law. And the reason is, as stated, penalties are deemed to be uncertain because people do not know how they are going to be enforced and what level they will be enforced at. And Islamic law prohibits uncertainty in contracts. So it is a great shame that this word has appeared, but very much in the same way that we talk about terms and conditions of contract, and of course that is inaccurate, as you now know. It should simply say terms of contract. You do not need the word conditions there. A condition is a kind of contract. A condition is a kind of term in the same way that a warranty is. You should not have the word penalties. There has been major issues going around courts all over the world when people appear in front of the court because they can't resolve their problems through negotiation. They start waving the contract in the air. The judge looks at it and says, why does it say penalty? Goodbye. Because they're sick of it. It's not for a commercial contract to penalize. Be very careful. And I'm sorry. I think I'm there. Sorry. All right. I've already mentioned some of these already, so I think I can possibly move past these. Other key terms there: passing of title when title belongs to somebody, legal possession, force majeure, etc. I think we can probably jump past that. A lot of companies will be very concerned about subcontracting when the supplier subcontracts elements of the work. Subcontracting. So, I have a subcontract clause in my agreement with Informa. I'm not allowed to ask somebody to do the work I've agreed to do without their written consent for obvious reasons. So we need to think about subcontracting clauses, how they might work, and finally we need to think about ethics and how we would use ethics and how ethics has a major impact on everything we do. So ethics is a really big issue. It needs to be remembered. Okay, a growing issue because bad ethics, badly drawn up contract terms, badly enforced contract terms damages companies' reputations. And when businesses lose their reputation, they lose their customers. And when they lose their customers, they lose everything. No customer, no business. And let me also say, no suppliers, no business. No business can stand without its customers. No business can stand without its suppliers. Simple expression, well-known English expression, no man is an island. You cannot exist without your customers and without your suppliers. It is impossible. Anyway, a general overview to try to demystify some of these issues related to contract terms. Unfortunately, we are already past time, so I want to thank you for all your attention. If you have any questions at all, please feel free to email them in, and I will do my best. Let me have a quick look here. Okay, I have got a couple of quick questions. Here's Sam. Why is it not favourable to make amendments on a contract and it is better? I'm going to ask if I can answer that in writing. Because it's a little bit more complicated. It probably needs quite a bit of explanation. But in simple terms, once you amend a contract, the supplier does not have to accept the amendment. You are actually, what you're doing is you're forming a new contract. I need to give you some issues. Very briefly, and by the way, I didn't say it is illegal. Sorry, somebody just asked about it being legal. I didn't say it was illegal. I said it's not advisable to amend a contract. It's strictly illegal, but it can null and void the contract. It can make it so it doesn't stand. Amendments need to be avoided where possible. Anyway, I'll write you a few more details on that. So I will post something that goes behind this, and we'll get it posted up behind it. After completion, can you please run the first 6 slides again? I think you'll be receiving those. I think that's the best answer. And of course, you can listen to this. All right. Okay. So yes, I take your points about the amendments, and I will deal with that. Dealers are giving manufacturers warranties, so it covers the indemnity articles. Yes, that's true. I think that means indemnity. Dealers are giving. No, not exactly. I'm going to have to check that. Sorry. No, that isn't exactly true. That is not exactly true. Again, I'll put a further note up about indemnification through third parties. Nowadays, Islamic law covers penalties. Not according to my sources. If you could tell me where that's come from, I'd be most grateful. Because I checked this again only a few weeks ago with an Islamic lawyer to make sure it hadn't changed. Please remember what I'm saying about penalties. And anyway, it's the word is the problem. Yeah. Penalties are not allowed in commercial contracts. Damages, yes. Penalties, no. Quite simple. But again, let me supply you with some more information. But please, if you know better than I do and it says Islamic law covers penalties in commercial contracts, it may well cover it. It says it's not allowed. If you're saying they are allowed as penalties, not as damages, please correct me and I will check it again. But please, I'm not talking about penalties. I'm talking about damages, penalties. Okay. I'll put another note on to supply behind that. Okay, guys. So what have I just promised? I'll put a separate note on indemnities, and I will put a separate note on how, more detail on why it's not favourable to amend contracts. Thank you.